Convention on Rights of Persons with Disabilities and its optional protocol was adopted on the 13th December 2006 at the United Nations. India signed and ratified the said convention on the 1st of October 2007. Consequently, it became necessary to align and harmonize the then existing laws, including the Mental Health Act 1987 with the said convention. Hence, new legislation was passed by the Parliament in the form of the Mental Health Care Act in 2017, thereby also repealing the Mental Health Act 1987. This new act provided for mental health care and services for persons with mental illness and to protect, promote and fulfill the rights of such persons during delivery of mental health care and services.
As we celebrate the journey of 75 years of India's independence, we bring to you another episode in our series titled 75 Years Laws That Shaped India. Laws that Parliament has passed during these golden years. I'm your host Hemant Batra, and today we are discussing another landmark law, the Mental Health Care Act 2017. Joining the discussion on this law, we have with us Shri Sujit Kumar, a member of Parliament in the Rajya Sabha. He is also a trained engineer, practicing lawyer, and public policy planner and maker. Welcome, Sujit ji, to the studios. We also have with us Dr. Rushi. Dr. Rushi is an associate professor and head of the Department of Clinical Psychology at the RML New Delhi. She has been advising on mental health issues for more than 2 decades now. Welcome, Dr. Rushi. Welcome, both of you, to the studios. Let me come to you first, Sujit ji. Sujit ji, as we saw in the introduction, the International Convention on Rights of Persons as to Disabilities was ratified by India in 2007. And after a decade, then we had this law, the Mental Health Care Act 2017, which repealed the Mental Health Act of 1987 as well.
Yes.
Why do you think that this law is regarded as a landmark law in the journey of 75 years of India's independence?
Hemanji, thank you for having me. First of all, let me wish and congratulate my countrymen for celebrating 75 years of our independence. And congratulations to you and your team for hosting this series on 75 leading cases or landmark legislations.
Thank you. Thank you so much.
Why is the Mental Health Care Act of 2017 a landmark piece of legislation? For many reasons. First and foremost, for the first time in our country, we have made mental health care a justiciable right.
Right.
For the first time, people of India have been able to use this legislation to claim and secure their fundamental rights and liberty when it comes to mental health.
Yes.
And this legislation has given them the right to access to mental health. So these are in consonance with the provisions of the United Nations Convention which you referred to. Secondly, I think this legislation has been very patient-centric and rights-based. It has taken a rights-based approach to mental health,
right,
which has never happened before. At least it has not been seen in the case of physical health care.
Right.
And thirdly, there are times when the mentally ill person is unable to articulate or communicate his or her preference with regards to treatment, with regards to decision.
Right.
So this legislation has given a choice to that person to have a directive when he is mentally well, whether he would like to go for a particular treatment, who would be his nominated representative in case some decisions have to be taken when he is unwell, mentally unwell. And again, this is a unique aspect of healthcare legislation in India. And finally, we have Section 309 of Indian Penal Code, which, as a lawyer, you would know, is a very absurd and bizarre section, because it punishes someone for attempting to commit suicide.
Right.
And all of us know that when someone is attempting to commit suicide, that person is not in the best of his or her mental health.
Right.
And on top of that, if he fails in his attempt, you are punishing him. So the Section 309 is still in the statute books, but it has been read down because of Section 115 of the Mental Health Care Act, which mandates that there will be no proceedings in case a person attempts to commit suicide. Rather, it is incumbent on the government to counsel, to care, to provide for services for that person, and also to ensure that there is no recurrence of that attempt.
Right.
So for a host of reasons, I think this is one of the finest pieces of legislation and the landmark, I would say, bill, an act.
Right. So, Gigi, definitely, the third point which you mentioned has a massive historical dimension, that it decriminalizes the offense of attempted suicide, which was punishable under Section 309 of the IPC, which you just mentioned.
Right.
But as a parliamentarian, I want to ask you that you just said that it has been read down, and even the courts of law have said that nobody could now be prosecuted or punished under Section 309. But why it has not been repealed as yet?
That's a very good question, Hemanji. I really wish that there is a private member bill in the parliament by some member. If the government is not bringing a bill to repeal this, there should at least be a private member's bill by some member. In fact, I'm seriously contemplating doing that in the monsoon session.
Dr. Rushi, coming to you, the main thrust of the statute, which is mental health care and mental illness. And these expressions have been defined in the Act. What do these expressions signify, and what are the processes by which one could determine that a person is challenged by mental illness?
Yeah, very pertinent question. So, like we have discussed, sir has already mentioned that it's really a very great landmark from the custodial care towards the mental health care. So, a lot of emphasis has been given on the mental health care in this Act towards the rights of the people who are suffering from mental illness and who are under treatment. Right. And coming to your next question, what you was asking, that the determination of mental illness. So, I would like to tell everyone that it is always done on the basis of some standard medical principles. So, there is nationally and internationally defined medical standards like the ICD-10, International Classification of Diseases, by World Health Organization.
WHO, correct,
right? So, in India, we are following that at the clinical practice, right? So, basically, the mental health professionals, they interview the patient on the basis of that ICD-10.
I see.
They make the diagnosis, right? And on the basis of the purpose of making diagnosis is only the treatment and the rehabilitation of the patient.
Right.
Nobody can make a diagnosis. Nobody has a right to make a diagnosis if the intention is other than making the treatment, other than if there is some pressure from the law or the court for some other reason. Those are some special clause. But otherwise, the reason should be the rehabilitation and the patient. So a lot of emphasis has been given on the patient care and the on the protection of the rights
and
of
rehabilitation, as you
and
said,
the rehabilitation as well.
So the purpose of identifying or determining is not to label them as they are mentally,
not
but
to label, not to stigmatize the person.
them.
The rationale should be the rehabilitation, the integration of the person in the community, treating him with dignity, with so much of respect.
Right. And the Act lays down a whole lot of statutory rights for the people suffering from mental illness or mentally challenged people. If you could illuminate on that.
So
for our
that is
viewers.
also for the first time it has happened that the patient, a lot of emphasis has been given on the rights of the patient rather than the rights of the, the family or the community essay. So 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 why they have given the emphasis on the individual rights, and what are those rights? I will just give a brief account of those. Like for
because
example,
there's a whole lot of rights. So
yeah, there are a lot of rights.
Just touch upon
but
some relevant ones.
Some relevant one, so the people should know who are seeking treatment in a hospital that what are their basic rights.
Right.
So they have a right to protect their, their dignity. They have all the right to protect themselves from any, humiliation, from any maltreatment or any misbehavior by the staff. They have all the right to report to the medical board if even they are not getting the adequate treatment. They are not satisfied with the treatment or the team. So they can report that thing. They have a right for the confidentiality. So no mental health professional or a health professional can reveal the information to any other external person. Only in few cases, in few circumstances, the information can be revealed when that person may be, harmful for the other people around
so the
in the ward.
Confidentiality has been given emphasis on. Which is
But if the life of some other person is at risk, then, or if the life of the patient is at risk, only these are the few circumstances is been defined in detail when we can break that we need to break the confidentiality in view of the welfare of other people. They have all the right to, approach anyone during their stay in the hospital. So if they want to seek any support from the legal aid services, they can appoint any attendant for them. They can write email to everyone, to anyone while staying in the ward. They can communicate. They have all right to refuse and accept the communication by anyone. So apart from that, the most important thing, for example, if there is a child under the age of 3 years, right, and he's been his or her mother is admitted in the hospital, so that child is also having a right to stay with the mother. We cannot deprive a mother from a right, we cannot separate them. Again, there is a clause that if the mother is so symptomatic, there is a risk of a harm on the child.
To the child or
then
any companion.
only we have to, and there is also for a certain period of time, for 15 days, then we have to review the condition of the mother. So, but other than that, we cannot separate them from the mother. Then the patients have a right to know about their medical treatment, that what sort of treatment they are seeking. Whether we need to reveal the diagnosis. We need to reveal and discuss the treatment part as well. So it is not on the monopoly of the mental health professional that we will decide that what sort of treatment we want to give. No, that we have to sit with the patient. We will discuss with them, and if they are not happy, they can take the decision. This act says that they have all the rights to take a decision.
What Sujit ji had also touched upon right in the beginning, the Supreme Court in several judgments over so many years has actually laid down that right to mental health is a fundamental right enshrined in Article 21 of the Constitution. And I think all these statutory rights are born out of constitutional fundamental right.
So they have a right to avail treatment and rehabilitation, as they have a right to seek the treatment for their physical issues, physical health issues. So the equal importance has been given to the mental health issues as well. So they have all right to avail that good quality of care, as they have all right to get their care for their physical health issues.
Well, our expert guests will be providing their insightful thoughts on this act after a very short break. See you on the other side of the break. Welcome back after the break. We are resuming our discussion on the historic law, the Mental Health Care Act 2017. According to India's National Mental Health Survey of 2015-2016, an estimated 150 million people, 15 crore people across India needed mental health care interventions. And definitely the number would have risen now all the more due to the challenges posed by COVID pandemic and the lockdowns. Well, before diving into the discussion with our guests, let us get some insight into the backdrop of this legislation in the parliament.
The Mental Health Care Bill 2013 was introduced in Rajya Sabha on August 19, 2013. It was later introduced and passed in Rajya Sabha on August 8, 2016. It was passed in Lok Sabha on March 27, 2017 and in Rajya Sabha on March 30, 2017. It received the President assent on April 7, 2017. The Mental Health Care Act 2017 was gazetted by notification on May 29, 2018. Here are some of the brief extracts of the debates on the bill in Parliament.
Unless and until community participation is there, we will not be able to provide proper sustainable mental health care.
इस विधेयक में ये भी कहा गया है कि आत्महत्या का प्रयास करने वाले व्यक्ति उस वक्त मानसिक रूप से ग्रस्त माना जाएगा और भारतीय दंड संहिता के तहत दंडित नहीं किया जाएगा। आप इस तरह का जो अपराध करने वाले रईस लोग हैं वो डिप्रेशन के शिकार बताकर इस दंड से बच जाएंगे।
This is a very good drafting of the legislation. Each and every provision of the bill has been well scrutinized, and it's a perfect bill. Even the long title as well as each and every clauses of the bill is very perfect and pakka.
In taking care of the mentally ill patients, in addition, this authority strive to integrate the various agencies involved in the mental health care and adopt a bottom-up approach in resolving the issue involving mental disorder.
जो 1987 का मेंटल एक्ट था वो इंस्टीट्यूशनल बेस्ड था। उसमें हम लोगों ने कोशिश ये की थी कि जो हम इलाज करें वो इंस्टीट्यूशन के अंदर हम कैसे रेगुलेटरी मेजर्स से हम इसको दिला सकते हैं, इस बात का प्रयास किया गया था। 2016 में जब हम इस बिल को जो एक्ट बनने जा रहा है उसको हम लेके आए हैं, तो हमारा फोकस इंस्टीट्यूशन से हट करके कम्युनिटी की तरफ गया है कि लोग समाज जीवन में रह करके ही अपना इलाज कराएं।
Sujit ji, the act in a way assumes that the people challenged with mental illness are fit enough to take decisions on their own with regard to their mental health care and protection of their health. However, there are instances which Dr. Rushi was also mentioning that sometimes they are not in a position, these situations are complex, their health is complex, where they need to appoint a representative or engage in some advance directives.
Right.
Can you please tell our viewers about those provisions which exist in this new statute of 2017?
Hemantji, this act empowers mental health patients by giving them participation rights in terms of the decisions they can take or their nominated representatives can take on their behalf. So there is a concept or the provision of advanced directive under Section 5 of the Act, wherein they can have a written directive when they are well, that should they suffer from mental illness, then what kind of treatment they would like to have, what kind of treatment they should not be administered,
okay.
And who take care of their business not in like
the commercial part,
but day-to-day affairs, and who would take decisions on their behalf, the nominated representatives. So all of this is codified. And it's codified in Section 5 of the Act, which is, I think, a significant provision, which was not there in any other healthcare legislation previously. So I think this is a great way of empowering the patients and giving them voice.
Absolutely.
Because as Dr. Rushi was mentioning, prior to this legislation, there was no voice for the patients. They were treated like criminals.
Right.
And another significant aspect of this legislation is that it mandates the government to have adequate number of mental health professionals within 10 years of enacting of this law, as per the international norms. And all of us know that there are, we just don't have enough number of mental health professionals in the country. So there is now a responsibility on the government to have adequate number of professionals, mental health doctors and paramedics and counselors by 2027. So I think that the right-based approach which we have been talking about, this is a wonderful exposition of that approach, right-based approach.
Yes, yeah. And the statutory rights are quite detailed.
Quite detailed.
Quite detailed.
Quite detailed.
Yeah. So definitely emphasis is there on statutory rights and specific statutory rights. So you don't have
empowerment of the patient.
And empowerment of the patient and giving voice. That's a very beautiful expression you have used, giving voice to the people who are challenged with mental illness. Dr. Rushi, picking up from where Sujit ji has left, there are a whole lot of legal obligations as well which are imposed by the statute on the government authorities, professionals, etc. Can you please tell us about those obligations and more so in context of the current times when people are facing so much of challenge because of COVID pandemic and lockdowns which took place in last 2 years. People have lost their health in a way, physical and mental in many cases.
Yeah. So that's true that every good thing has some pros and cons also. Yeah. So we have appraised and appreciated enough about the positive things about the law, but about the act. Yes. But certainly there are few things which are quite challenging for everyone, for the people who are working in the field of law or the police personals, for the government officials, for the mental health professionals. Right. I would say. For example, like, because, it is talking about the right-based approach, the participation of the person. So there are so many things because we are thinking in terms of their rights. We are talking about the statutory rights. Right. So a lot of documentation is there in the hospital, if you will see. So because emphasis has been given on a lot of documentation, so the health professional and the mental health professional, they are occupied most of the time in making the notes,
so
maintaining
that process
the files,
needs to be simplified.
Recording of the document while keeping all the confidentiality and all. And that takes so much of time also. So it's very time consuming also. Right. So if you will look at Sir has initiated that there is a lack of human resource in the country. Like we don't have enough mental health professionals. Right. So but if they have to spend so much of time in the documentation and in all the structured procedure to follow, so definitely the government has to think, though Act is also talking about that, that we have to enhance the manpower. Right. So that the Act is talking about the, talking on the promotion of mental health, the prevention of mental illness and, minimizing the stigma, reducing the stigma. Apart from that, a lot of emphasis has been given on the enhancement of the manpower. This is very important. We have to emphasize the equity also, the fair allocation of resources in the community. Right. Yeah.
Well, it's time to take the viewer's question. This time the question has come from Supriya from Noida. Let's hear her.
To whom can I report a case of mistreatment and abuse of a person with mental illness in my locality?
If the abuse is there in a mental health establishment, then the patient or his or her representative can take it up with the medical health officer of that establishment,
okay.
The medical superintendent or of equivalent rank. Right. If the patient or the representative is not satisfied with the response, then it can be escalated to the medical board, the mental health board. Right. Further escalation can be done to the state authority, which has the principal secretary or the secretary, the health secretary or the principal health secretary of the state, the director of health services and members from the civil society as members. Right. But if the abuse is found in a residential premise or in a private establishment, then the person, the patient or the representative can approach the station house officer of the nearest police station, who is then mandated to bring it to the notice of the magistrate.
I see.
And once it comes to the notice of the magistrate under section 101, then it's incumbent on the magistrate, either through, if the magistrate is aware of this happening, either through the report of the police officer or otherwise, then the magistrate is mandated to get the patient produced before him.
So it has a criminal
It has
consequence.
criminal consequences, yes.
Yeah, because I was reading it, there is an imprisonment of 6 months and for
Yes.
repeated offence 2 years.
Yes. So I think, Supriya, sensitization and awareness is what is necessary.
Right.
So, I think everyone should be sensitized that if there is an abuse, then they should not be silent.
Right.
They should definitely approach the nearest police station or some social worker who can then help them to get the redressal.
Right.
Similarly, a lot of violation of rights have been seen for the children also. So under the POSCO Act, they can
Yes.
report. The
that is
people
true,
should
yeah.
in the community, they should know that where to report, how to report, what to report.
Well, we had a meaningful discussion with our notable guests. Thank you so much for joining us and giving us deep insight into this law. Well, that's all we have in this episode of the program. You can send your feedback at Sansad TV at sansad.nic.in. You can also connect with us on various other social media platforms. Thank you so much for watching this show. Goodbye, good luck, and namaskar.